morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has not been sworn.
All right, we will get you sworn. Madam Clerk?
Raise your right hand. Do you swear to translate from English to Spanish, Spanish to English? Testimony is given.
Did you hear that?
Oh, yes, I do. To the best of my abilities, Laura Bretaña, certified state Spanish interpreter.
Thank you. We are doing orange interpreter cases. There were none for Osceola today.
Okay, thank you.
All right.
He does too, right? So you do.
Sí, claro.
There is contact, Your Honor.
Can you test to make sure the microphone is working or the headphones are working? Okay. So we have a witness as well, so we're going to do it over the air. So take the headphones off.
Okay, gracias.
Okay, thank you.
All right, so we're doing it in open court. I've called the case of Alvaro Jukemax, which is, I don't know what number would assist you, Madam Clerk.
22 MM 427 AW.
Thank you.
Nos encontramos en el caso de Álvaro Duke Mac, 2022 MM 0427 AW.
Deputy, when you have a moment, if we could get this TV moved, because it's literally right in the way of the witness. I don't need it done this moment. It's just the tall part's completely blocking, yes. Maybe we can go forward or backwards or. That, a little bit forward would be great, and that would be perfect. Thank you so much. Okay, sir, I'm appointing the Office of the Public Defender to represent you.
Muy bien, señor, se ha designado a la oficina del abogado de oficio para que les represente.
I also want to let you know you have the right to remain silent. Anything you say can and will be used against you.
También quiero dejarle saber que usted tiene derecho a permanecer callado. Todo lo que usted diga podrá y será utilizado en su contra.
You're charged with simple assault with intent or threat to do violence, domestic in nature.
Se le acusa a usted de intimidación con la intención de hacer daño relacionado a violencia doméstica.
I review the charging affidavit or the arrest affidavit. I do find probable cause for the charge.
Habiendo leído el documento acusatorio, determino que existen indicios de criminalidad para la acusación.
Ma'am, what is your name?
Señora, ¿cuál es su nombre?
Linda.
Linda.
You're the alleged victim in this case, correct?
Señora, usted es la presunta víctima del caso, ¿correcto?
Sí.
Yes.
I don't want to discuss the facts of what happened. My question is, are you afraid of Mr. Jukemax?
Ahora no quiero discutir los hechos del incidente. Meramente quiero preguntarle si usted le teme al señor Duke Mac.
Solo cuando lo miro borracho.
Only when he is drunk.
Do you want contact with him?
¿Usted desea tener contacto con él?
Sí.
Yes.
My understanding is you do not reside together. Is that correct?
Tengo entendido que ustedes no conviven. ¿Eso es correcto?
Sí.
Yes.
If I were to allow non-hostile contact, would you have any hesitancy about calling 911 again if he became violent?
Señora, si yo permito el contacto entre ustedes, pero sin hostilidad, si él se volviese a tornar violento, ¿usted dudaría de llamar al 911?
No.
No.
Okay. Bond is set at $500 with PTR.
se concede fianza en la cantidad de $500 con supervisión del programa de libertad provisional.
and random urinalysis at defendant's expense.
Se le harán pruebas de orina aleatorias y esto a costa del acusado.
It doesn't? Disregard the PTR.
Muy bien, por favor, tachen la supervisión del programa de libertad provisional.
So bond is set at $500.
Entonces, tiene una fianza de $500.
You're ordered not to consume alcohol as a condition of your release.
Como condición de su puesta en libertad, señor, se le prohíbe el consumo de alcohol.
No hostile contact with the alleged victim.
Se le prohíbe el contacto hostil con la víctima.
Maintain separate residences.
Se le prohíbe la convivencia con la víctima.
And that is all. You may be
Y eso es
seated.
todo.
Wait a minute. He has an open case, battery and resisting without violence.
Señor, usted tiene un caso abierto de agresión física y desobedecer a las autoridades.
Does it involve the same victim?
En este caso, ¿es la misma víctima la que está involucrada?
It appears to.
Parece ser que sí.
PTR, can you assist on that?
El programa de libertad provisional podría ayudarme con esto.
I'm trying right now.
Estoy verificando.
And that is in case 2022 MM 330.
Y estamos hablando del caso 2022 MM 330.
The clerk has advised me that it does in fact involve the same victim.
Se me ha hecho saber que ambos casos son con la misma víctima.
One of the requirements of being out on bond is that you not pick up any new charges.
Señor, uno de los requisitos de encontrarse libre bajo fianza es que no se le vuelva a acusar de un nuevo ilícito.
At this time, I'm revoking your bond in the other case and setting your bond at zero, no bond, until you're brought before the presiding judge.
En cuanto al otro caso, se le ha revocado su fianza, se impone prisión preventiva hasta que se presente usted ante el juez que preside el otro caso.
Please, you're dismissed.
Muy bien, hemos terminado.
Luis Londano, or Londano. Sir, I've appointed the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you in a future proceeding. You're charged with one count of battery, domestic in nature. I've reviewed the charging affidavit. I find probable cause for the charges. You do qualify for PTR, and that's what I'm ordering in this case, along with a no contact order with the alleged victim. And maintain separate residences, no return.
Your Honor, what was that bond amount? I'm so sorry.
PTR.
PTR. Okay.
Wilfredo Torres. Sir, I'm appointing the Office of the Public Defender to represent you.
Okay.
What?
You have the right to remain silent. Anything you say can and will be used against you. You are charged with larceny, grand theft in an amount greater than $5,000 but less than $10,000, and passing forged or altered instruments. I do find probable cause for the charges. Do not qualify for PTR. Bond is set at $1,000 on count one, $150 on count two.
Your Honor, what was that second amount?
150.
Thank you.
Antonio Poptek, Poptex.
Bond amount.
I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you in a future court proceeding. You're charged with one count of battery, unlawful touching, or striking. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at $500. You're to have no contact with the alleged victim,
Ajá.
and that is.
Yes.
Va. Gracias. Gracias.
Thank you.
Yameles Padron Riesco. She's getting her headphones on. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with the following. Affidavit. This was, Counsel, you were going to get the actual affidavit referenced in the affidavit.
Yes, Your Honor. I attempted to contact the arresting officer, and I was not aware that I needed to contact the officer from the warrant. So I asked her for the basis for her stop, and she said it was just because there was a warrant out, an active warrant.
You said,
Okay, so I contacted the arresting officer from this affidavit. I did not contact the warrant officer that made the initial stop. It was indicated that the reason for the initial stop was that there was an active warrant. I do have an email from the officer that made the stop to that effect, but I don't have the actual affidavit mentioned in the warrant.
all right. Well, here's what I'm going to do, because I don't think this inquiry is appropriate for IAs. I have a warrant. The warrant finds probable cause for trafficking in fentanyl, 4 grams or more, sale and delivery of fentanyl, sale and delivery of cocaine, unlawful use of a two-way communications device. At this time, I am going to decline to go behind the warrant to determine whether, in fact, that was properly based on the reference warrant in the body of the warrant before the court. And I'm going to honor the warrant as it was presented and set bond in the following amounts: $100,000 on count one, $7,500 each on counts 2 and 3, $1,000 on count 4. To the extent any other conditions are set forth in the warrant, they will also apply. And that is all. Madam Interpreter, I do not show we have any other cases that we need you for, so thank you for your assistance today.
Thank you, Your Honor.
Emmanuel Bullard, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with abuse of elderly or disabled adult and battery. I've reviewed the charging affidavit. I find probable cause for the charges. You do not qualify for pretrial release. Bond is set at $1,000 on count one, $500 on count two. You're to have no contact with the victim. And that is all. Demontrius Michael. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you in a future court proceeding. I've reviewed the charging affidavit, which charges you with battery on a corrections officer and aggravated battery on a corrections officer. I do find probable cause for the charge. In each instance, bond in count one is set at $1,500. Bond in count two is set at $10,000. Is the state requesting a no contact order under the circumstances of this case?
Yes, Your Honor.
All right, I'm opposing a no contact order as well on the victims. I'm sorry, on the no contact with the alleged victims in this case. All right? Thank you. Maria Alford. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with aggravated assault with a deadly weapon. I find probable cause for the charge. Before I set your conditions of release, ma'am, what is your name?
Maria Alford.
Please raise your right hand to be sworn. Do you swear and affirm the testimony you're going to provide is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do not want you to tell me anything about this case factually. My questions have to do with your level of, or desire to have any contact with Ms. Alford. Are you afraid of Ms. Alford?
No,
Do you want contact with her?
I want help for her.
I can't hear you.
I want help for her.
You want help for her? All right,
Yes.
that's a different question. Do you want contact with her? Would you like to not have contact for a while she works on getting that help?
Exactly, yes.
All right. Do you reside together? Do you live together?
We don't live together. She lives with my mother, but my mother is 84 years old, and I make frequent trips to my mother to help care for my mother.
What is your relationship with her?
With Maria,
Yes.
that's my sister.
Okay. So your sister lives with mom. Mom's 84. You're worried about mom.
Yes,
All right. But mom wasn't involved in this instance.
Mom almost was injured in the incident, but she wasn't harmed.
What's mom's name?
Rosetta Alford.
Okay. But your sister is visiting from out of town, so she doesn't live here, is that right?
I'm visiting from out of town.
You're visiting from out of town. I'll get
Yes,
you.
I make
figured
frequent
out.
visits here to help care for my mother by me working in the medical field. So I'm in Orlando at my mother's often.
All right, thank you. Bond is set at $3,500.
Your Honor, can we get the victim's name for the record one more time? It was spoken over by the defendant.
Go ahead and tell us your name again. Are you Barbara Moore?
Yes,
Okay.
Thank you.
The charging affidavit only references you as the victim. Although mom was present, it doesn't indicate any of the violence was directed toward mom.
right.
So I am setting bond at $3,500. I am ordering that there is to be no contact between, with you as the victim in this case.
How is that going to be possible if she lives with my mom and I'm there?
Good point.
to-
No hostile contact. I'm going to amend that. You all don't reside together, so I'm going to make that a no hostile contact order.
Okay.
She's to possess no weapons or firearms. Anything else
may
is
I
beyond
say-
this hearing.
May I say one thing?
If
I
it
may?
doesn't involve what happened,
Yes.
go ahead.
A lot of it happened is because of the drugs and the alcohol. So if you can,
Is that reference, hold on, let me see if that's referenced in this affidavit. There's nothing in this affidavit indicating drugs or alcohol were a factor, so I'm not going to order anything at this time. All right, good luck.
thank you.
Crispin Alley.
How's it going?
I'm appointing the Office of the Public Defender to represent you. And I'm also advising you that you have the right to remain silent. Anything you say can and will be used against you. You are charged with aggravated battery on a pregnant person. I've reviewed the charging affidavit. I find probable cause for the charge. Ma'am, what is your name?
Letitia Clements.
Louder, please.
Letitia Clements.
All right, raise your right hand to be sworn. Do you swear and affirm the testimony you're going to provide is the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Are you the victim in this case?
yes.
Are you afraid of your,
No, I'm not afraid of him. He's the only person I have, man. I'm not even from here. He is the only person that I have that's here. I need him out. I can't do this by myself.
I show that you've been married for 6 years, you're expecting your first child. Um, And you're not afraid of him and you want contact, right?
Yes, I'm not afraid of him at all. I just need him home. I really and truly do. He
Okay.
start works Monday.
Well, he doesn't qualify for direct PTR or pretrial release, so I'm going to go ahead and give him a bond of $1,000 with the additional criteria that he have no hostile contact with the alleged victim.
And Your Honor, would you consider RR in this case, considering that within the four corners of the arrest affidavit, there's an argument for mutual combat mixed with the fact that he's a primary source of income for a pregnant wife?
Like he's all I have. If he doesn't get out, I don't know what I'm gonna do. I'm not from here. I don't have no family. He's my only family. I don't have nobody, literally nobody. He is all
It's
that
also,
I have.
it's also not clear from the affidavit whether, who rather was the primary aggressor in this case.
He
I know
didn't
the
even
police made a
touch me.
determination at the scene, but it's not clear from the reading that I got that it's,
I'm going to release some ROR in this case, but I am going to include the condition that there be no hostile contact, any hostile contact. Screaming, shouting, yelling is enough to violate him. All right? Derek Bowles.
Present, Your Honor.
Mr. Bowles, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you in a future proceeding. You are charged with aggravated battery on a pregnant person. I've reviewed the charging affidavit. I find probable cause for the charge. Ma'am, state your name, please.
Daviana Gordon.
Raise your right hand. Do you swear and affirm the testimony you're going to provide is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Are you the victim in this case?
Yes.
Are you afraid of Mr. Bowles?
Not at all. And if I can request, I just really want him to come home, please.
You want him home too?
Yes, please.
Um,
I'm currently 8.5 months pregnant, and he's currently under active leukemia treatment.
He's currently what?
He's actively under leukemia treatment. He just got diagnosed with leukemia, and he's currently under treatment. And I really would like him home because we are a really good, strong couple. I just, I thought that the police coming would have facilitated just a peaceful so that we can try to calm the situation down, but the police actually made it a little bit worse. So I really want him to come home. I did not intend to press charges, or I'm not scared of him. We have a beautiful daughter. I really want him home. He's been my boyfriend since I was 14. We're going to be 26, and it's very, very important that he's home because we have a 1-year-old daughter. I'm 8.5 months pregnant, and he's currently doing his leukemia treatment.
All right, I heard all that already, so give me a second. Let me hear from the state.
Our concern at the state is that the child was present and witnessed this incident. It stated that the child attempted to get, the 1-year-old was present when this happened, and she was right next to it. And then again, my concern also is that she is 8.5 months pregnant, and regardless of wanting contact, this stressful situation is not good for the baby or the 1-year-old. While we can appreciate that the victim wants contact, we would ask for conditions to help protect the children.
May I say something?
What would those conditions be that you're seeking?
Is he eligible for PTR?
No.
I
Why
would
is,
be
why is he
requesting-
not eligible for PTR? Nature of the charges?
Yes, ma'am.
Nature of the charges, that's why.
Um,
Other than that, he scored 0, correct? I mean, he scored 0 on the risk assessment. He's a college graduate. He has no history.
I understand, and at the very minimum, no hostile contact, but for my conscience, I would like to put on the record, no contact.
Okay. I'm going to allow contact, but I also want to see if you have an opportunity to be heard. No, your lawyer.
Yes, Your Honor. I'm going to ask for RRR in this case, considering his recent diagnosis, testimony from the victim, and the life circumstances. They just closed on a house. They've been together for a long time. And again, he's just been diagnosed with leukemia. So the cancer treatment is something that at this point in his life is primary. And getting that help outside of here is going to be the most important thing in his life at this moment.
All right. I'm not going to do ROR, but I'll give him a $1,000 bond. I am going to order that there be no hostile contact. I'm going to order that you're to not possess or own any, not possess any weapons or firearms.
Okay. Your Honor, he has a license to carry a weapon.
That's great, but he's going to have to, I said not possess. He doesn't have to sell them. He
Okay.
needs to store them somewhere, put them somewhere, give them, turn them into law enforcement to hold. I don't want the guns in the house,
Okay.
Until the case.
Until the case is resolved.
all right?
All right, and then,
Which is why I amended my initial ruling, which was going to be do not possess or own any weapons or firearms. So aside from that, good luck, ma'am.
Thank you.
Jermaine Chambers. I'm appointing the office of the, do we have Jermaine? Okay. I'm appointing the office of the public defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with aggravated assault with a deadly weapon, battery, commission of a domestic battery by strangulation, and battery domestic in nature. I find probable cause for each of the charges. You do not qualify for PTR. Bond is set as follows: $5,000 on count 1, $1,000 on count 2, $1,000 on count 3. You're ordered to have no contact with the alleged victim, not possess any weapons or firearms. If you reside together, maintain separate residences. One-time return in the presence of law enforcement, if needed, to retrieve your personal possessions. You're also out on the charge of battery dating violence in 2022 MM 04429. One of the conditions of that bond is that you not pick up any new bonds. I'm revoking your bond in that case and setting it at a 0 bond until such time as you're brought before the court.
Okay.
Johnny Johnson. All right, I'm appointing the office of the public defender to represent him. I'm finding his refusal to be a waiver of his appearance today. He is here based on 2 warrants. One is for failure to appear, and one is for robbery. Probable cause was previously found. I'm going to leave bond at 0 on both charges. Along with, on the robbery count only. Oh, I don't have the affidavit. No contact with the alleged victim, do not return to the scene, possess no weapons or firearms. He's also out on bond in 2021 CF 7679. I'm revoking his bond in that case and setting his bond at 0 at this time. Daquan Jones. I'm appointing the Office of the Public Defender to represent you. I'm letting you know you have the right to remain silent. Anything you say can and will be used against you. Your charge was 1 count of battery, committing domestic battery by strangulation, and 1 count of false imprisonment. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at $2,500 on the battery count, $1,000 on the false imprisonment count. No contact with the vic, no return, maintain separate residences, do not possess any weapons or firearms. One-time return if needed.
What, may I have those bond amounts one more time? I'm sorry.
I'm sorry?
May I please have those bond amounts one more time? I couldn't hear.
2,500 and 1,000.
Thank you.
What is that? Okay. LaShonda Jones.
Your Honor, would you consider, I'm sorry, I was pressing the off button. Would you consider doing an unsecured bond in this case because the client lives in North Carolina, he's not able to get anybody to secure his bonds?
Is that a cash bond? What is an unsecured bond? I don't know what an unsecured bond is. If you can find somebody that'll issue a bond without security, good luck.
Yeah.
While they confer, given that he is from out of state, the state would object to an unsecured bond regardless.
Do you know what it is?
No, but it sounds like something I need to object to.
Something in North Carolina that they don't do that here.
Then
Or
no,
that's- yeah,
I'm not going to
so-
allow it.
Yeah,
I don't think you can find a bonding agency that will issue you an unsecured bond. But I don't ever mandate
they don't do that here.
what type of bond you provide. You have to provide a surety bond. I'll leave it to the bonding agency to determine what collateral they want.
You have to contact them.
All right, next case, LaShonda Jones. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you in a future proceeding. You're charged with false imprisonment and battery, dating violence. I've reviewed the charging affidavit. I find probable cause for the charge. Your bonds are set as follows: $5,000 for the false imprisonment, $1,000 for the battery, which is a dating violence charge. You're to have no contact with the alleged victim, maintain separate residences, no return to the in-town suites where this occurred. And I want to explain, no contact means no contact, direct or indirect communications through third parties or otherwise. That is all. Jeffrey Sheffield. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with 1 count of false imprisonment, 1 count of battery, domestic in nature. I've reviewed the charging affidavit. I do find probable cause for the charges. Ma'am, what is your name?
Jessica Townsend.
Raise your right hand. Do you swear and affirm the testimony you're going to provide is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I show you're the victim in this case, is that correct?
That is correct. I don't want to go any further. I want to drop everything.
All right, I understand that. You want to drop the charges?
Yes, I don't want to proceed with anything. We're going to be maintaining, he's actually going to move with his mom, so we're not going to have any contact. I don't want to go any further.
Okay, so it's going to be, you're good with no contact?
We're good with anything. We're fine.
Is the 7-year-old a common child in common?
No,
Do you have any children in common with him?
no, we don't.
Has he already moved out?
His stuff is already there. His mom is going to come pick it up.
Okay. Are you afraid of him?
No,
Bond is set at $1,000 on each count with the additional criteria that there's to be no contact with the VIC. You may return on a one-time basis if needed to retrieve your personal possessions. No return other than that. And
do we, because of the children, and I'm being honest, his daughter's birthday is this week. I am a part of her life. He's a part of my kid's life. I don't want to say it'll be a no contact. Her
all
birthday is
right,
coming up.
I'll do a no
I'm being
hostile
honest.
contact. No hostile contact.
Yeah.
Any kind of hostility, voices raised will violate him.
We're not going to have any of that.
Thank you.
There's no way to get this just dropped completely because I don't want to go
You have to
court.
talk to the state about that, not the judge.
Oh, I don't,
I can't do that today. That's something that they'll contact you about later on when.
I'm
they
not-
contact the charge.
I'm removing the no return and the one-time return, so it's simply a no hostile contact.
Thank you, Judge.
Thank you.
You can let the state know that when they reach out to you regarding the charges.
okay, thank you.
No problem.
Lavon Thomas. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with home invasion robbery with a firearm, aggravated assault with a firearm, domestic in nature, and battery, domestic in nature. I find probable cause for the charges. Does the state want to be heard on bond?
Yes, Your Honor. We would be asking for the higher end of the bond schedule, given his history. He has several convictions and was recently released in 2020. There's a prior aggravated battery with a deadly weapon, as well as burglaries, possessions, and resisting charges as well. There's also some tampering with physical evidence, so we would just ask for the upper end of the bond schedule.
Thank you. Does the defense care to be heard?
No, Your Honor.
All right. Bond is set on count one at $50,000. You are ordered to have possess no weapons or firearms. Count two, I'm setting your bond at $5,000. Count three, I'm setting your bond at $1,000. You are to have no contact with the VIC, no return to the scene of this location. And relinquish any and all firearms in your possession, custody, or control to law enforcement within 24 hours of your release. David Hamby. I'm appointing the Office of the Public Defender to represent you. Your charge, I'm also advising you, you have the right to remain silent. Anything you say can and will be used against you. You're charged with one count of battery, dating violence. I find probable cause for the charge. You do qualify for pretrial release, so that's what I'm ordering, along with the requirement that you have no contact with the alleged victim, maintain separate residences. one-time return to gather your personal possessions, relinquish any firearms in your possession, and that is all. Yes. You're going to release the weapons within 48 hours of your release from incarceration. Return them and turn them into law enforcement. And no weapons, correct. Sharif? Hannah?
Yes, please.
I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with one count of battery, unlawful touching or striking. I find probable cause for the charge. Bond is set at $1,000, no contact with the Vic. Maintain separate residences, one-time return in the presence of law enforcement to gather your personal possessions. That's all.
Your Honor, what case number is that for? I saw that,
What case number is it
yes,
for?
case number.
Madam Clerk?
22 MM 314 AA.
Thank you.
Christopher Holloway. Sir, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with one count of battery, dating violence. I find probable cause for the charge. You do qualify for PTR. I am releasing you under PTR conditions with the requirement that you're to have no contact with the victim. Patricia Peluso. Ms. Peluso, I am appointing the Office of the Public Defender to represent you. I'm advising you, you have the right to remain silent. Anything you say can and will be used against you. You're charged with one count of battery, domestic in nature. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set. You qualify for PTR, so I'm going to release you under, stand by. Thank you. Ma'am, what is your name?
Kelsey Crane.
All right, raise your right hand, please. Do you swear and affirm the testimony you're going to be providing is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Are you the victim in this case?
Supposedly, yes.
Are you afraid of Ms. Peluso?
No.
Do you want contact with her?
Yes.
Do you reside together?
No. I'm a military spouse. I live in Virginia. I'm going home after this.
Okay, just down here for a visit?
Correct.
What's your relationship with the defendant?
My mother.
Okay.
I would like everything dropped if possible today.
I can't drop it. The state attorney's in charge of that, and I don't know that'll happen today.
Okay.
Nothing's been filed.
They will be reaching out to you to do their investigation. At that time, you can advise them.
Okay, thank you.
So at this time, I'm releasing you under PTR conditions with the requirement that you have no hostile contact with the victim. Thank you, ma'am.
Thank you.
Yeah. I miss it? Pedro Rivera Caban. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with 1 count of battery, domestic in nature. I've reviewed the charging affidavit. I find probable cause for the charge. You do not qualify for pretrial release. Bond is set at $1,000. No contact with the alleged victim.
This is your, here's our information.
Ramon Rodriguez Martinez. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with violation of a domestic injunction. I find probable cause for the charge. State, do you want to be heard on bond?
Yes, Your Honor. This is an ongoing issue. The defendant does have prior convictions for child abuse, and he is to remain away from this address specifically, and he was found about 50 feet away. We would be asking for the upper end of the bond schedule and for a no contact, as redundant as that sounds.
You said he was found about 50 feet away. Was it this incident where arguably the allegation is that he broke into the home, trashed the apartment, had the keys to the vehicle, et cetera?
Yes, Your Honor, I believe that's correct. At this instance, he did break in. Not sure why he's not charged with that, but that's what the victim told police.
Does the defense care to be heard?
No, Your Honor.
So if I didn't say it, I do find probable cause for the charge. Given the flagrancy of the alleged violation and the allegations of the damage that was caused and the specificity of the injunction in place with regard to not returning to the protected person's home, I am setting a high bond of $20,000 in this case for violation of the domestic injunction, with the additional criteria that you are to have no contact with the alleged victim. At some point, sir, you'll realize no contact means no contact. Any violation of that no contact order or the domestic injunction will land you right back where you are. I'm also because I don't see it, going to order that you are to relinquish any weapons in your possession within 24 hours of your release, and you are not to possess or own any weapons or firearms. Trevor Sebarin, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with battery, domestic violence, 1 count. Before I set your release conditions, ma'am, what is your name?
My name is Liloti Prashad Subaran.
Raise your right hand. Do you swear and affirm the testimony you're going to provide is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Louder, please.
Yes, ma'am.
Okay, we're recording this, so if I can't hear you, I'm sure it won't be picked up on the recording machines. Are you the alleged victim in this case?
Yes, ma'am.
I don't want to discuss what happened. My question is, are you afraid of Mr. Subaran?
No, ma'am.
Do you want contact with him?
Yes, ma'am.
Do you reside together?
Yes, ma'am.
All right. Thank you, ma'am. You qualify for pretrial release, so that's what I'm ordering in this case, with the requirement that you not have any hostile contact with the victim. Makeshia Smith. Ms. Smith, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with battery, domestic violence. I've reviewed the charging affidavit. I find probable cause for the charge. You do not qualify for pretrial release. Bond is set at $1,000, no contact with the victim. If you reside together, you are required to maintain separate residences. You may return one time in the presence of law enforcement to gather your personal possessions. No weapons or firearms. That is all. Anthony Voltaggio.
Just take that. That's it.
I'm appointing the Office of the Public Defender to represent you in the Voltaggio case. I'm finding his refusal to constitute a waiver of his appearance today. He's charged with battery, domestic violence. I find probable cause for the charge. $1,000 bond, no contact, no return, separate residences, no weapons or firearms.
Thank you, Judge.
Aki Black.
Yes, ma'am.
I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with possession of methamphetamine, MDMA, ecstasy, possession of heroin, possession of cannabis, less than 20 grams, possession of a firearm or ammunition by a convicted felon. I find probable cause for the charges. Bond is set as follows. $1,000 on count 1, $150 on count 2, $100 on count 3, $5,000 on count 4. You are also out on bond on possession of cocaine and resisting an officer without violence in 2022 CF 4940. I'm revoking your bond amounts in those in those cases, and setting your bond at 0. One of the conditions of that surety bond is that you not pick up any new charges. You have violated that condition.
Yes, but Judge, it's no information in that case, and also I have no representation in that case, so.
Yeah. Your Honor, would you appoint
Was
the
that
public-
case no info state?
I can check, and then while I check that, is there also a moving violation?
Perhaps. Yes. I'll do that one. Why don't you check that? We'll look into that, sir. Meanwhile, you are also charged with moving traffic violation, driving while license suspended, revoked, or equivalent status. Bond in that case is set at $500. You are ordered not to drive without a valid driver's license as a condition of that case. And we are looking up the
other case.
the other case.
Please, Judge.
An Osceola case?
No.
Orange County.
20,
Okay.
22, find it?
22 CF.
224940.
Okay. I see that. It's not. 22 CF 49. This case is with intake as of May 27th, 2022. I see the 2 arrest charges. At this time, I don't see any filed charges.
There's no information, there's no representation under the case. I just don't want to be sitting in jail.
Can you check that case, please?
He, Your Honor, I'm not sure what the timeline is for felonies, how many days we have to file. But he was picked up on that case May.
Here's what I'm going to do, counsel. I'm going to take no action in the open case because of your
Thank you, Judge.
confusion, all right?
And Your Honor, can you also appoint the public defender in that case?
I will.
Thank you.
Judge.
All right.
And then, Your Honor, I was looking up his case. Will you repeat the bond and for the moving violation? I know you said no driving, but I did miss the amount.
500.
Thank you.
Felicia Brown William,
Yes, ma'am.
I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with failure to appear at your arraignment on June 29th in 2022. You were given a bond in that case of $2,000 where it will remain. You're also charged with failing to appear. You've got 3 of them, actually. So in the first case, you got a $2,000 bond. In the second case, You failed to appear at an arraignment on June 30th. Bond was set at 0. In the third case, you failed to appear for a case management conference on June 29th of '22. Bond was set at 0. Bonds will remain as set.
Judge, what I'm saying is,
Nope, not going to hear it today. Talk to your lawyer.
I guess what about the Osceola thing they talking about?
If you have a holding Osceola, this is just orange.
Sharmera Friday. You have the right to remain silent. Anything you say can and will be used against you. I'm appointing the Office of the Public Defender to represent you. You're charged with grand theft, third degree. It's an amount greater than $750, but less than $5,000. I reviewed the charging affidavit. I do find probable cause for the charges. Bond is set at $500.
Here's our information. If you find out before.
And that is all.
Have a good one, thank you.
Miguel Garcia Rivera. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with burglary to an unoccupied structure and criminal mischief. I find probable cause for both charges. Bond is set at $2,500 on count 1, $100 on count 2. You're ordered not to return to the location of this incident.
That's your bond. That's your bond total.
Michael Granum. I'm appointing the Office of the Public Defender to represent him, finding a waiver of his appearance today. He is charged with battery on a law enforcement officer, resisting an officer with violence, possession of drug paraphernalia, soliciting without a permit. I find probable cause for the charges. Bond is set at $1,500 on count 1, $100 on each of the other counts. No contact with the victim in count 1. Arthur Gray. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with battery on a law enforcement officer, resisting an officer with violence, trespass in other than a structure or conveyance. A review of the arrest affidavit reflects there is probable cause for the charges. Bond is set as follows: $3,000 on count 1, $1,000 on count 2, $100 on count 3. No contact with the alleged victims in counts 1 and 2. You are also out on ROR in 2022 CF 852. Charge was a battery with one prior battery. One of the conditions of your release is that you not pick up any new charges. You have done that. I'm revoking the conditions of your release, holding you no bond until such time as you are brought before the judge in that case. Brandon Griffin. You refused? I am appointing the Office of the Public Defender to represent Mr. Griffin. I'm finding his refusal to appear today constitutes a waiver of his appearance and his right to be present.
Okay.
Did you have a question, sir?
No, no.
He refused
Okay.
on this one.
Yeah, that was my.
He is charged with first-degree murder. It's a warrant case. Probable cause was previously found. Bond will remain as set at 0, no bond. Audrey Jones? I'm appointing the office of the public defender to represent you.
Yes.
You have the right to remain silent. Anything you say can and will be used against you. You're charged with criminal mischief in an amount greater than $1,000. You do not qualify for PTR. Bond is set. Defense, do you want to be heard on bond?
Just a moment, Your Honor. All right, no, Your Honor.
Okay, bond is set at $1,000. I'm also adding a no return to this location.
Your attorney will be-
Cedric Jones. I'm appointing the office of the public defender to represent Mr. Jones. I'm finding his refusal constitutes a waiver of his appearance. He's charged with possession of MDMA ecstasy, possession of cannabis in an amount less than 20 grams, possession of drug paraphernalia. I've reviewed the charging affidavit. Probable cause exists for the charges. Bond is set at $1,000 on count 1, $100 each on counts 2 and 3. Kenneth Lyman. I'm appointing the office of the public defender to represent Mr. Lyman. Mr. Lyman, are you waiving his appearance today?
Yes, Your Honor.
All right, let's have a waiver of his appearance. He is charged with possession of a controlled substance with intent to sell, resisting an officer without violence, trespassing on property after warning, petty theft. I find probable cause for each of the charges. Bond is set as follows: $15,000 on count 1, $100 on each of the other counts. As a condition of his bond, he is ordered not to possess or consume illegal drugs or controlled substances without valid prescriptions. He is also out on bond in 2022 CF 7294. I am revoking his bond in that case and setting a new bond of 0, no bond, until such time as he's brought before the judge. Tyrone Mitchell. I am appointing the office of the public defender to represent you. You have the right to remain silent. Anything you say can be used against you and will be used against you. You're charged with petty theft with 2 prior convictions. Pursuant to the capias, probable cause was previously found. Bond was set at $1,500 with pretrial release conditions. I am not going to disturb that bond. There was also the requirement that there be no contact with the victim co-defendants and no return to the scene of the offense or any Dollar General.
That's your bond amount?
Rydell Perdomo.
This is the bond amount.
Sir, I'm appointing the office of the public defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with possession of cocaine. I've reviewed the arrest affidavit. I do find probable cause for the charge. Bond is set at $1,000. You're also out, is he also out on bond in 2021 CF 012821? In that case, the charge was aggravated assault with a deadly weapon. One of the requirements of that surety bond is that you not pick up any new charges. You have done that. I'm revoking your bond in that case, setting your bond at 0, no bond, pending being brought before the judge. Gabrian Wilson. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with 1 count of petty theft pursuant to a warrant previously issued. Probable cause has already been found. That warrant set your bond at $1,500. And I am not going to modify it. There are additional conditions under the bond, under the warrant that is in place. No contact with witnesses or victim and no return to the scene without law enforcement. Jasmine Lane.
Yes, ma'am.
I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with reckless driving. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at $500. You're also out on bond in 2022 CF 8119 for possession of cocaine. I'm taking no action with regard to that case. Jarvis Sears. Oops, hold on. What happened to Ulysses Oxlodge? All right.
How are you?
Sir, you're charged with a non-moving traffic violation, failure to register a motor vehicle. I've reviewed the charging affidavit. I do find probable cause for the charge. Bond is set at $500. Freddie Cannon? I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with trespass on property after warning. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at $500. You're also out on bond in 2022 CF 7390, burglary of a conveyance. Is the state asking for a revocation of the bond?
Yes, Your Honor, given his history.
Okay. I'm going to revoke the bond in that case.
And bond was stayed at 500 in this case, correct?
Yes.
This case.
Set your bond at 0, no bond in the 2022 CF 7390 case until such time as you're brought before the judge. Rashard Fisher.
He's present.
I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you in a future court proceeding. You're charged with trespass on property after warning. My review of the arrest affidavit reflects probable cause. Bond is set at $500 on that charge. You are also out, however, on bond in 2022 CF 7641, finding these new charges result in a violation of your conditions of release in the existing case, revoking those conditions of release,
My bond was paid
setting
at
your bond at
500.
zero, no bond, until such time as you're brought before the judge. Robert Gammas? What happened to Gammas?
22017172. Mm-hmm.
Thank you. Rakeem Gore. Mr. Gore, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with criminal mischief in an amount greater than $200 but less than $1,100. I've reviewed the arrest affidavit. I find probable cause for the charge. Bond is set at I'm going to make bond at $500 in this case, along with the condition of no return. You're also out in 2022 CF 5631 on ROR. I'm going to revoke the conditions of your release in that case. Is that the only, is the state asking for that revocation of ROR?
Yes, Your Honor, we would ask for a revocation and for a new bond to be set if possible.
All right. I am revoking the bond in that case, but I'll go ahead and give you a new bond today of $1,000. Yeah. Yes. Mondell Gray. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're charged with trespass other than a structure or conveyance. And I find probable cause for the charges. Bond is set at $250, no return to the Wawa at issue in this case.
I don't want you to be no, I don't need a lawyer.
Gregory Lane?
Well, this is your information. If you want to know anymore.
You don't.
Mr. Lane, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with 1 count of trespassing to an occupied structure or conveyance. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at $250, no return. You're also out in 2022 MM 52. I'm taking no action. What's TRES?
Trespass.
Okay. Same location, different location?
I'm not sure. I can
All right.
check, but
I'm going to take no action in that
Thank
case.
you, Your Honor. Here's your information.
Richard Parsons. Mr. Parsons, I'm appointing the Office of the Public Defender to represent you.
Yes,
You have the right to remain silent. Anything you say can and will be used against you. You are charged with trespassing on a structure or conveyance. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at $500 with a no return requirement. You're also out on bond in driving while license suspended or revoked with knowledge. I'm taking no action in that case. Lucinda Stevens. I'm appointing the Office of the Public Defender to represent Ms. Stevens, finding her refusal to constitute a waiver of her appearance today. She's charged with trespass on property after warning. I find probable cause for the charge. Bond is set at $500. Kimberly Welzinski.
Close enough.
Say it again?
They say close enough, it's Wilson.
Okay, Wozinski. I'm appointing the Office of the Public Defender to represent you. You are charged, you have the right to remain silent. Anything you say can and will be used against you. You're charged with 1 count of trespassing, failure to leave property upon order by owner. I find probable cause for the charge. Bond is set at $500. You're directed not to return to the discount beverage location identified in this affidavit. And that is all. Karen Williams. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you in a future proceeding. You are charged with violation of a domestic injunction or contract by having contact. I find probable cause for the charge. Bond is set at $2,500. You are again ordered not to have any contact with the victim in this case. No contact means no contact, direct, indirect, or passing messages through multiple people down the line. Exaloy Morales.
Exaloy, Your Honor.
Exaloy Morales. Sir, I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You're here pursuant to a warrant issued out of Volusia County for failure to appear. Underlying case involves a battery. That warrant set your bond at $1,000. Raquel Richardson. Thank you. Mr. Richardson? Okay. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are here pursuant to a charge of trespassing of a structure or conveyance issued out of Marion County. That warrant set your bond at $1,000 and indicated you would be held for pickup. Richard Rodriguez. Sir, I'm appointing the Office of the Public Defender to represent you. You are here pursuant to a warrant issued out of Clay County, Florida, for violation of your probation. That warrant set your bond at 0. I am also advising you that you have the right to remain silent, and anything you say can and will be used against you. Dakota Chavez. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with violation of your probation. The Judge Calderon set your bond at 0, no bond at this time until such time as you're brought before him. Justin Gray. I'm appointing the Office of the Public Defender to represent you. You have the right to remain silent. Anything you say can and will be used against you. You are charged with 3 different cases today: violation of your probation, your bond in that case is set at 0, no bond. Driving under the influence. Having an unlawful blood alcohol due to the influence of alcohol. That's one case, by the way. I find probable cause. Bond is set at $500. With the additional condition that you are not to possess or consume any alcohol or illegal drugs, and leaving the scene of a crash with property damage. I find probable cause for that as well. And bond is set at $1,000. Yes. Yes, what? Reporting? All right, and you're directed to comply with your reporting requirements upon release. There's no violation of that at this time, correct? All right. Anthony McIntyre.
You had applied in the other line.
Mr. McIntyre doesn't want to see us this morning, so I'm going to find his waiver. His refusal is a waiver of his appearance today. I am appointing the Office of the Public Defender to represent him. He is charged with violation of his probation. Bond in that case is set at 0. He's got 2 of those cases, and in each of those cases, bond is set at 0. He's also charged with possession of methamphetamines. The arrest affidavit does reflect probable cause. Bond in that case is set at $2,500. Jonas Duranville. I'm appointing the Office of the Public Defender to represent Mr. Darrenville. I'm finding his refusal constitutes a waiver of his appearance. He's charged with disorderly conduct. There is probable cause for the charge. Bond is set at $250. Raymond Rance. I'm appointing the Office of the Public Defender to represent Mr. Rance. I'm finding his refusal constitutes a waiver of his appearance. He's charged with disorderly conduct. I find probable cause for the charge. Bond is set at $250. Anybody else?
he had opened his hands to address reporting requirements. I think it's said that. Agenda. He had reporting requirements upon being released.
Okay. I would note that Mr. Rodriguez has reporting requirements upon being released. So that should be noted on his paperwork. Thank you. Anything else?
Nothing further.
We are adjourned, folks. Have a great week.
Thank you.
So you're here pursuant to a warrant for failure to appear at your arraignment. That warrant set your bond at $500. Please be seated. Can you just keep that with the Ashley Bodenchance.
President approaching.
You're charged with petty theft, third or subsequent offense. I've reviewed the charging affidavit. I do find probable cause for the charge. Your bond is set at $2,500. You are not to return to the Walmart located at 3250 Vineland Road in Kissimmee. Terry Bodenchance. Be seated, please.
One moment, Your Honor. I apologize. President approaching, Your Honor.
You are charged with resisting arrest without violence and with petty theft, third or subsequent offense. I've reviewed the charging affidavit. I do find probable cause for the charge. I am setting your bond on the resisting arrest in this case at $1,000 and the petty theft, third or subsequent offense at $2,500. I'm also ordering that you not return to the Walmart located at 3250 Vineland Road in Kissimmee. Take your seat. Hubert Credit.
The judge was given the information, Your Honor?
Yes.
He does qualify for direct PTR without a monetary bond.
I don't have, where are those sheets? Hold on. Well, let me recall that one then, and I want to recall the one behind it. I usually put them on top, so. Okay, so Terry Bodenchance qualifies for direct PTR?
Terry Bodenchance does qualify for direct PTR as to both charges.
Then I will order direct PTR as to both charges. I also want to recall Ashley. She does not qualify, correct?
Correct. She does not qualify at this time. She has another legal constraint out of state.
Okay, thank you. Then I'll make no change on that one.
Your Honor, for Bodenchance, is that PTR with a bond or without?
Yes,
With the bonds?
with the bond. Let's do it with the bond. I'm going to do a $1,000 bond and PTR. No, only on Terry. Let's go back. I'm not changing Ashley's bond situation at all. Terry Bodenchance. This is a third or subsequent offense, so I'm going to require a bond with PTR, and that bond is going to be $1,000 with PTR.
And Your Honor, to be clear, the $1,000 goes towards the petty theft or the resisting without violence?
The resisting.
Okay, so on petty theft, he's ROR'd?
Yes.
Okay, thank
No,
you.
direct PTR.
Okay, thank you.
Take your seat.
Have a seat, sir.
Hubert Credit.
President approaching.
Sir, you are charged with one count of trespass on property, not a structure or conveyance. Bond is set at $150. Marquez,
Your Honor, I
back
apologize.
up.
Mr. Credit wanted to ask the court respectfully whether the court would entertain an offer at this time.
I'm not, so I'm not going to do offers today, and please. And I did find probable cause.
Thank you.
Marquez Fincher.
President approaching.
Sir, you're charged pursuant to an out-of-county warrant for failure to appear. Warrants out of Lake County. It sets your bond at 0, no bond. Shamarie Flowers.
President approaching.
Sir, you're charged with battery, unlawful touching or striking, and child abuse without great bodily harm. A warrant was issued. Probable cause was previously found. Before I set any conditions of release, let me find out who is here. Could you please state your name?
Ebony Flowers.
All right. Raise your hand and be sworn. Do you swear and affirm the testimony you're going to provide is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Ms. Flowers, are you the alleged victim in this case?
Yes, I am.
I don't want to hear about the incident. What I want to know is information reflecting on my issuance of conditions of release.
Okay.
Are you afraid of him?
No.
Are you afraid of him for your child?
No, ma'am, not at all.
Do you want contact with him?
Yes, ma'am.
If he were to become abusive, either with you or with your child in the future, would you have any hesitancy about calling 911?
No, ma'am, not at all.
How old is your child?
My oldest is 13. And then I have an 8-year-old.
Does the state want to be heard?
Yes, Your Honor. Given the charges, the charge of child abuse it's without great bodily harm. Regardless, given the fact that there are children involved, the state would be asking for no contact, but at the bare minimum, no hostile contact.
Thank you.
Your Honor, may defense be heard?
Yes.
Regarding Mr. Flowers, I did confer with Mr. Flowers. He advised that he is the primary caretaker of the family. In addition, as the alleged victim stated in open court, she is not afraid. She does want contact. And defense would be requesting, if the court is considering any no contact orders, instead of no contact, no hostile contact, would ensure that the alleged victim in this case would be able to contact law enforcement if she feels any situation arises between the parties.
Thank you, counsel. At this time, I am finding there is I don't need to find that. This is a warrant case. Probable cause was previously found. All right, for the conditions of release, On the battery count, bond is set at $500. On the child abuse without great bodily harm, bond is set at $1,000, both with PTR. Does he qualify with a bond or
No,
not
he
at
does
all?
not.
Okay. Leave, and no PTR. I'm going to order that there is to be no hostile contact. And you're not to possess any weapons or firearms. Be seated. Dylan Griffin.
Refusal.
I'm appointing the Office of the Public Defender to represent him. I'm finding his refusal to be a waiver of his right to be present at this proceeding today. He's charged with retail theft, petty, one prior theft conviction. I've reviewed the charging affidavit. There is probable cause for the charge. Bond is set at $500. No return to the Walmart in St. Cloud. Julio Guzman Garcia.
Present and approaching, Your Honor. Defense would like to be heard regarding probable cause
Count one. On count one?
on both counts.
Okay. Sir, you're charged with burglary, curtilage or structure, carport, larceny, and battery, simple touching or striking, domestic in nature. There's a probable cause challenge. I think I already agree with you on count one, but let's put it on the record.
Your Honor, regarding count one, burglary, curtilage of structure or dwelling, carport, larceny, there are no facts within the four corners of the police report that explain that Mr. Garcia entered the property with an intent to commit a crime. In addition, according to the statute of burglary 810.024A, curtilage is defined, there is case law that defines a curtilage as a building not totally enclosed to be part of structure within meaning of the burglary structure. And I do have a citation of Chambers versus State, 4th DCA, 700 Southern 2nd 441. In addition, in the police report, there's no description as to where exactly this alleged entrance of the property occurred. And regarding count two, the battery, although the alleged victim stated that Mr. Garcia allegedly open-handed smacked her on the left side of her face one time, the paragraph 2, the police officer states Carolina did not have any physical markings consistent with the statements made by her. And in addition, the sentence after that states that she does not wish to prosecute. Therefore, there is an inconsistency regarding the statements made by both Mr. Garcia and the alleged victim, Ms. Carolina. And in addition, there were no independent witnesses that could affirm or deny whether there was in fact a physical altercation. The only explanation that we have is that Mr. Garcia himself stated that Ms. Carolina was a primary aggressor, and then he swung his hands. Therefore, defense would be objecting to probable cause on both counts 1 and 2.
Thank you. Response.
Yes, Your Honor. As to count 1.
I only want to address count
Okay.
one.
For count 2, it's in the
I
affidavit.
only want to address count one.
Oh, okay. Count 1 is the burglary. Sorry, I got confused on which count.
They're also married.
Yes. So, based on the officer's statement, Julio was outside of the home in the areas connected to the home without the permission of Carolina, and while he was there, it is alleged that he did commit a battery. So we would contend that that's the crime therein. But he was outside of the home in the areas surrounding the home, and we would argue that that is the curtilage. If there's no argument as to count 2, that's all the state has at this time.
Okay, thank you. At this time, I do not find probable cause for count 1. I'm going to release him ROR on count 1. As to count 2, I do find probable cause. Bond is set at $1,000. There's to be no contact with the alleged victim. No, I think y'all live next door to each other. So just no contact with the alleged vic and maintain separate residences. Be seated, please. Vincent Hayward.
President approaching, and Your Honor, defense would like to be heard regarding probable cause.
Sir, you are charged with battery, simple touching, or striking. We have a probable cause challenge. Go ahead, counsel. Make it brief.
Your Honor, regarding probable cause, the police officer in this case attempted to obtain surveillance in this case, and he was unable to. In addition, there were no independent witnesses that could confirm or deny the alleged altercation between both parties.
Let me make sure I understand something that you are saying, counsel. Are you saying in every instance where a crime is alleged, there needs to be independent verification to establish probable cause?
No, Your Honor, not in every instance, only certain circumstances.
Well, how would you describe that then? How would you distinguish that?
Well, in a
You don't need it in rape, but you do need it in battery?
No, Your Honor. In a situation like this, where the police officer also attempted to view cameras, there were no cameras that were in the view where the incident occurred. In addition, there are facts that allegedly an altercation occurred between both parties, but there is alleged to have been a small scratch on the alleged victim's left ankle. We don't know how that scratch came about. It could have been before the incident, after the incident. So in this case, because there may have been no independent witnesses to corroborate these statements, that's why defense would object to probable cause.
Counsel, response?
No independent witnesses are necessary to establish probable cause. No surveillance is needed. And it is sworn to in the affidavit that the statement from the victim was taken. It was sworn to that the scratch came from this incident. And that's sufficient based on the four corners of the affidavit to prove probable cause.
I agree. I do find there is probable cause for the charge. Bond is set at $500. No contact, no return, no weapons or firearms. Melvin Jefferson. Sir, you're charged with the following: 2 counts of possession of a controlled substance without a prescription, and 1 count of possession or use of drug paraphernalia, 1 count of possession of marijuana under 20 grams. I've reviewed the charging affidavit. I find probable cause for those charges. Your bonds are set as follows: $1,000 on count 1, $150 on count 2, $100 on count 3, $100 on count 4. You are as a condition of your release on counts 1 and 2, not to possess controlled substances without a valid prescription. You are also charged with grand theft auto, pursuant to an active warrant. Probable cause was previously found. That warrant set your bond at $2,500. Please be seated.
Your Honor,
Lillian.
I apologize, but to be clear, regarding both possession counts, each was $1,000?
No, $100.
$100 each. And then
Yes.
Drug paraphernalia, $150, and the marijuana, $100, correct?
1,050, 100, 150, 100, 100.
Thank you.
Lillian Stout Cox.
President approaching.
Ma'am, you're here pursuant to a warrant issued out of Okaloosa County for violation of your probation. Underlying charge was a DUI. Your bond was set at $0. You may be seated.
I have a special circumstance right now.
Talk to your lawyer, and she will entertain a motion for bond.
My 1-year-old's in a hospital, and I have a 2 and a 3-year-old down here as well.
Talk to your lawyer, and she can do an emergency motion to set a bond. Courtney Taylor.
Present and approaching.
You are charged with possession of a controlled substance without a prescription and possession and/or use of drug paraphernalia. Probable cause was previously found pursuant to a warrant that set your bond at $2,500 on count 1, $150 on count 2. Please be seated. Omar Vargas.
Your Honor, Mr. Vargas is present and approaching. Because of the nature of the charges, would the court consider waiving the reading of the charges?
If you so request, I would.
Defense respectfully requests, Your Honor.
All right. Sir, your attorney has requested a waiver of the reading of the charges, which I have granted. However, I do find probable cause for those charges. There's nobody in the box. Bond is set as follows. $5,000 on count 1, $150 on count 2, $5,000 on count 3, no contact, no return. Maintain separate residences if they reside together. Do not no possession of weapons or firearms. Be seated. Bruce Terrell, Terrell Murtha.
Present and approaching.
This is the one I needed a supplemental
Yes, Your
affidavit
Honor.
on.
The state has no additional information at this time.
All right. So we are here. Yesterday, probable cause was found for count 2, but not count 1. The state has not filed a supplemental affidavit as to count 1. Accordingly, I am RORing him as to count 1 at this time.
Thank you, Your Honor. And also no PC on count 1?
Correct.
Thank you.
Thank you, counsel. You can be seated, sir. I show that's it, right, counsel?
Yes, Your Honor. May defense be excused?
Yes, have a great day. Thank you for your assistance.
Thank you, Your Honor. You as well.
Let's do Orange County. TV's still on. Do you want to turn it off? Or I have to do that.